Hi, everyone. Welcome to today's immigration chat. Today, we're going to be talking about you ready for it? The Liberian Immigration Act. It is a green card act that allows Liberian nationals to get a green card in the US. I'm going to be telling you all about it, who qualifies, what complications can come up, and how you can solve those complications. Okay, that's what we're going to be talking about today. Now, I am Lillian Chukura from Lily Legal. We are an immigration law firm and we help our clients get status for themselves and for their families using the US immigration law system. So, if you have any questions about this or anything else, you can book a time to talk to me by going to my website, lilylegal.com, or by calling my office at 508 443 1788. So, like I said, we are going to be going over the Liberian Green Card Act. That's what I call it, but the real name is the Liberian Refugee Immigration Fairness Act, which was passed, like packed, passed in 2019 by Congress. This is a law. Okay, this is not an executive order. This is a law. There is a deadline to apply. This is a program that basically changes lives. So you can go from not having a green card to having not only getting a green card, but also being able to apply for citizenship immediately once you get your green card. Okay, so this is why I love this program, and I want to make sure that if you qualify, that you are going ahead and applying, you are knowing about this, and that you are sharing this with your community, because if someone qualifies and they miss the deadline, it is going to be a shame. So we want to make sure that if someone qualifies, they are applying and they are getting their green card. Okay, so if you are just joining me, please do go ahead and ask me your immigration questions in the comments, and I am happy to respond. As always, tell me where you're joining me from, and if you, like I said, if you have questions as I'm going along, ask me. If you are watching this on the replay and you have questions that come up, go ahead and put it in the comments. I will go back and respond to your questions. So please go ahead and do that. These immigration chats are for you. Okay, I'm here for you. I'm here to answer your questions. Immigration is a very complicated area of law, and I want to make sure that our community, the immigrant community, is getting the right information. So go ahead, ask me your questions, and we can get started. Okay. Now, the first thing you need to know about this is that there is a deadline. Okay, that's the first thing you need to know. The deadline was December 20th, 2020, but Congress extended it for another year. So you have until December 20th, 2021. Okay, so you have a few months if you haven't applied to go ahead and apply. That's the deadline for you to actually apply, not the deadline for your case to be approved. Okay, again, December 20th, 2021 is the date that USCIS, right, US Immigration, has to receive your application. If you put it in the mail on December 20th, 2021, unfortunately, you're going to be out of luck unless it's being delivered the same day. Okay. So that's really the key here, is making sure that you do not miss the deadline. The next thing I want to tell you is that this is not just for the main applicants. So if you are a Liberian national and you qualify, but you have, let's say you have children that were born in other countries because of the war, and they're not able to get a Liberian passport, well, guess what? If you're applying, they can apply as well with you and be able to get status through this. If you are applying and you have a spouse that came into the US 2 years ago and they don't meet the residency requirement, and you meet the requirements, your spouse can benefit from this as well. So this is not just for the individual, this can impact an entire family. So that's why I want to cover this. That's why I will keep covering this until it no longer exists, right? Until the deadline passes and Congress doesn't renew it for another year, I will stop. That's when I will stop talking about this. Until then, I will keep talking about it. Okay. So, first thing you need to know, in order to apply for this, you must be a Liberian national. Okay. And you just, the thing is, you can have a Liberian passport, and that makes you, that's your proof of Liberian nationalism. If you only have a birth certificate, that's going to be difficult, right? USCIS will want a passport or a naturalization certificate from Liberian government. So that's something to keep in mind, is that if you're going to be applying for this, you should know that the best proof that you can use to show that you are a Liberian national is your passport. So if you haven't applied for your passport, or if your passport has expired, go ahead and renew it. Go ahead and file for your passport so that you have it ready to go. I know it does take time sometimes to have those passports done, so you want to get started immediately. So that's the first thing. You're a Liberian national. The second thing is that you have continuous physical presence. Continuous physical presence. What does that actually mean, right? It means that you have been in the US from November 20th, 2014 until the day that you filed your green card application. You are only allowed to have been outside of the US in that time frame for 180 days. So that's about 6 months. So if you, let's say you came in before November 20th, 2014, and then you were gone from the US for a year, and then you came back, unfortunately, you wouldn't qualify, because it says it right there in the act that you cannot have an absence of more than 6 months. So it's really important that we pay attention to the dates and the deadlines and all of those things, because it can cause your application to be denied if you are not presenting evidence that you have been here since November 20th, 2014. Now, the great thing about this is, if you can show that you've been in the US way before that, that's great, right? And how do you show continuous physical presence? Simple. If you have bank accounts that can show transactions, that's great. If you have filed taxes, if you have worked, if you've had children in school, right? Or if you yourself were in school, you can get those records to show that you have been physically present in the US. So those are the things that you need in order to actually show physical presence. And you have to show it from November 20th, 2014. If you can show it for, let's say, you came in 2012, and you can show your presence from 2012 to present, that's great. That means when you get your green card, the 2012 date is when it will say that you got your green card. I'll get into that a little later. Okay. So, you have to show that you're Liberian national. You have to show continuous physical presence in the US. And then you have to also show that you are admissible into the US. Okay. This means that all the rules that apply to other people that are applying for a green card apply to you as well. So, criminal convictions, you should be talking to an immigration lawyer to make sure that if you do have a criminal conviction, that it's not something that will make you inadmissible. Okay. And part of that is if you Okay. If you have a charge for, let's say, possession of marijuana, and you were convicted or you pled guilty, well, that's a problem, because if you have a drug offense, it makes you automatically inadmissible unless you meet an exception for a waiver. Okay. And the waiver is very strict. So you have to make sure that if you do have a criminal conviction, it's not something that will make you inadmissible. And if it is something that will make you inadmissible, that you have a waiver or that you qualify for a waiver. So that's something I help my clients do, is when you come to me, we look at your whole history. We look at your documentation, we look at the criminal conviction to make sure that not only are we looking at whether you actually qualify, that's only one part of it, right? We have to make sure that whatever conviction you have does not make you inadmissible, that we're not putting you into the immigration system when you don't actually qualify. So that's something that is a big deal to me. And I make sure that we go through that at my firm with every single person. Now, there are certain things that are waived for people that are applying under this. Okay. So typically, if you are applying for a green card and you don't have any documentation of how you came into the US, that's going to be a problem, because if you cannot show that you legally entered the US with a visa or that you were paroled into the US, that means you cannot adjust your status in the US. You would have to leave. But with this program, the great thing about it is it does not matter. If you came in without documentation, or you don't know where those documentations are, as long as you can still show when you came in, that you came in before November 20th, 2014 with other documentation, that would be still acceptable. So that documentation requirement of how you entered the US is not required. Okay. Now, if you are, like I said, if you're present without admission or parole, not a problem. Okay. If you worked without authorization, which most people, if you came in to the US and you've been here since 2014, you have worked. Okay. You've done some form of work in the US so that you can actually stay here and continue living and supporting yourself. Now, if you're in that situation and you qualify for this, I have some good news for you. It doesn't matter. The US government has said that they don't care that you work without authorization if you are applying under this act. That is something that's specifically set up for immediate relatives of US citizens. Only immediate relatives of US citizens get this. Okay, get to work in the US without authorization and still be able to get a green card in the US. So that is a, a step above and beyond what an immediate relative of a US citizen can do. And then something else, the whole being present in the US without admission, if you are married to a US citizen and you are present in the US without admission or parole, meaning you didn't come in with a visa and the US government did not give you permission to come into the US, you cannot get a green card in the US. Okay, let that sink in. If you are married to a US citizen and you came into the US without a visa, and the US government did not give you permission to come into the US and stay, you cannot get a green card in the US. You will have to apply for a waiver, go back to your home country, go to an interview, get your visa approved, and then come back in with that. But with this act, you skip all that process, right? With this act, you are able to get a green card in the US, even though you overstayed your visa, even though you didn't come in with a visa, okay? Even if you crossed the border into the US, you would still qualify, because that is not something that will make you inadmissible under this act. That is something that will make you still eligible, even though in other categories, for example, spouse of a US citizen, it will make you inadmissible in the US. You have to follow certain steps in order to then get a visa outside of the US and come back in with that visa. So it is one of the things that makes this act so special and so important for people to know about. Okay. So now we know, right? Liberian national, continuous physical presence since November 20th, 2014 until the day that you file, that you still have to be admissible, but certain things are waived, like you coming in without authorization, you overstaying, you working without authorization. All those things are waived. Now, if you have a criminal conviction that's considered an aggravated felony, you are not eligible. Again, you cannot determine what an aggravated felony is. You should be talking to an immigration lawyer, because some things that might seem like a felony in state court might not be an aggravated felony, and or might not make you inadmissible. So it's really important that you know the difference, right? Just because something is a misdemeanor in state court, it could it could be an aggravated felony in federal. So it's really, really, really important that you know the difference, and that you know whether um, the conviction will actually, right, actually make you inadmissible. So an aggravated felony, even one aggravated felony, will make you inadmissible for this purpose. Two or more crimes involving moral turpitude, if you are convicted of two or more crimes involving moral turpitude, will make you automatically not eligible. This is even if you qualify for a waiver, you're automatically not eligible. If you participated in the persecution of others, which is basically persecuting people based on their gender, race, ethnicity, all of that, you are not eligible. So the law is set up in a way that they really don't want someone that has serious criminal convictions or multiple criminal convictions to be able to benefit from this act. So it is super important that you, before you decide, oh, dang it, I have a criminal conviction, I don't qualify. Well, it might not be a criminal conviction that makes you not eligible, right? So I've had people tell me, oh, well, I had a restraining order against me. Does that make me not eligible? Well, no. A restraining order is not a criminal conviction. Now, if you violate the restraining order, that's a different issue. That's a criminal conviction. But um, if you just have a restraining order against you, you could still qualify if you don't have other criminal convictions, because a restraining order by itself is not a criminal conviction. But a violation of a restraining order is a criminal conviction. And it's seen as a domestic violence issue for immigration purposes. And that is something, again, that will make you inadmissible. So it's something to really pay attention to and keep in mind, because I'm telling you, it makes a difference. It makes a difference when it comes to criminal convictions. It really, really makes a difference. So I'll tell you a little story. Okay. So I had a client that came in, and they were convinced that because they had certain criminal convictions, that they would not qualify under this act. And she was insistent that she, she had TPS, she was ready to apply, but she wanted to make sure that the convictions wouldn't be an issue. Well, unfortunately for her, she had one conviction that would have been an issue, but we needed to make sure that it would have actually been an issue. So if you have conviction for possession of marijuana, that can be an issue. If you have any drug related convictions, that can be an issue. Okay. But in her situation, she was lucky because we were able to find out that the possession was less than 30 grams. And because it was less than 30 grams, she qualified for a waiver. Okay. So, because the conviction was for possession of marijuana under 30 grams, she was able to qualify for a waiver. We were able to go ahead and start the waiver process. And then the best part of the whole thing is, for a waiver, you need a qualifying relative. For most waivers, you need a qualifying relative. Luckily for her, her conviction was over 20 years ago, right? Convictions over 15 years, if you qualify for a waiver, you don't need a qualifying relative. So she was in a situation where she really thought she was out because she had the possession, right? But she didn't have a qualifying relative for the waiver. However, we were able to get her court records, the lab records that tested the marijuana to see how much they actually found, and we were able to then use that information to determine that not only does she qualify for a waiver, but she doesn't need a qualifying relative. And now this person that came in thinking that they might not qualify for this act now not only qualifies but has a great chance of being approved because they actually sought out assistance, right? They actually asked the question of, do I actually qualify? Does these convictions make me inadmissible? Does it make me not eligible for this act? That's the thing with immigration. You don't want to assume, okay? You don't want to assume that you qualify, and you definitely don't want to assume that you don't qualify, okay? So that's the thing about immigration that I love, and the reason, right? And the reason that I do these every single Friday for you is so that you can ask me questions, you can find out information, you can get the knowledge that you need in order to make the right decisions. Because this woman would have went on without status, without even applying, because she thought she didn't qualify. So that is why I do what I do. That is why I'm here every single Friday, giving you information, answering your questions. And even if you're watching this on the replay and you have questions, go ahead and ask me. I am willing to give you the information because it is that important to me. It is that important to me that you have this information. Okay? Now, let's continue and talk about the other great parts of this act. So, before I said that if you are married to a Liberian national that qualifies under this act and they are applying under this act, that you too can apply. Okay? So, spouses of Liberian nationals and unmarried children, okay? Spouses and unmarried children. That's important, because some people may think that if the child is under 21, they're fine, they can apply. But if they are married, if you're 20 years old and you're married, you are automatically not considered a child for these purposes. So it's really important that you pay attention to the words I'm using. So, spouse and unmarried children of eligible Liberian principal applicants can apply. So, what does that actually mean? It means that just because you're married to a Liberian national that already has a green card, but they're not applying under this, you cannot apply. Okay? So, being married to a Liberian national doesn't mean you automatically qualify to apply for this. The Liberian national also also has to be applying under this. And if they are, then you can go ahead and apply as well. Okay, let me repeat that. If you're married to a Liberian national, even if you are not a Liberian national, okay, and they are applying under this act, you can apply as well. Now, here's the requirements though. Your relationship with the Liberian national has to exist before they file their own application. So once, let's say you are filing through your spouse, but you two got married after she filed. Well, unfortunately, you don't qualify. Your marriage has to take place before the Liberian national principal applicant files their petition. Before their petition is received by USCIS, your marriage has to have taken place. That's what that means. Okay. And once that takes place, it doesn't matter if you are a Liberian national. Okay. It doesn't matter. It doesn't matter if you have not been present in the US since November 20th, 2014. Even if you've only been in the US for 1 year, you would still qualify because the principal applicant qualified and is applying, and you are their spouse or their unmarried child, you now qualify without having to meet the strict requirements of having to, be from Liberia, having to have been in the US since November 20th, 2014. You don't have to meet those requirements. That's the great thing about this. So know that and go ahead. And if you are in that situation, your spouse has filed or your parent has filed, and you think, oh, I didn't meet the requirements, well, unless you have unless it's a requirement that makes you inadmissible. So if you have a criminal charge that makes you inadmissible, those are the things that we really should be paying attention to. But if you meet all the requirements as far as inadmissibility, there's nothing in your immigration history, there's nothing in your criminal history that makes you inadmissible. As the spouse or unmarried child of a Liberian national that's applying under this, you can file without being a Liberian national and without having continuous physical presence. So that's great. You must meet all the other requirements, but those two very important requirements that's limiting, right? Those are the most limiting requirements, because if you came in, let's say in 2015, but your spouse has been here since 2014 and they are applying, you now went from not qualifying because you came in a year after the cutoff date to now qualifying because your spouse met the requirements and your spouse is applying. So that's something to keep in mind and know that it's a possibility. And that's why I say that an entire family can literally go from not having status to having their green card and then being able to apply for citizenship right away. So that's something to keep in mind. And you don't have to file at the same time as the principal applicant, but you have to file before the deadline. So let's say your spouse already filed or your parent already filed. You can still file. You just have to make sure that you file before the deadline of December 20th, 2021. That's really the key. File before the deadline and you'll be fine. Now, I want to talk to you about another complication. So we already talked about the criminal conviction being a complication that can lead to you not being able to get status under this act. Now let's talk about misrepresentation and fraud. What does that actually mean? How does that come up? So let's say this usually comes up in one of two ways. So if you are a Liberian national and you qualify under this act, but at some point in your history, right, whether you filed with a spouse and the case just didn't work out and USCIS didn't believe your marriage, that's one way. If you, when you were coming to the US, you filed a visiting visa and you put in some not so correct information, like you said that you were married or that you had kids that you didn't have, and it comes up at your interview, that's going to be a problem. That's going to make you inadmissible. And I have seen this happen with several people. I've had people come to me after they already filed, after they already had their interview, after USCIS already said, hey, we don't want to approve your case. And this is the reason why. Because your marriage that you had with this specific person years and years and years ago, we decided that that marriage at that time was not real. So therefore, you committed fraud or misrepresentation. So we're not going to approve this application unless you apply for a waiver. I've seen this happen several times. So if you were married before and that and there was an application filed for you based on that marriage, you need to pay close attention. Okay. Before you file, or if you already filed, you still need to pay close attention because it can come back. It can come back. It can keep you from being able to get your green card. So it is really, really important that you pay attention to that. It's very, very important that you pay attention to that. So before you start the process, that's why I said if you know that you have any negative things in your immigration history, like you filed before and your case was denied, those are situations that you should be talking to an immigration lawyer before you start the process. Okay? Because we know how to help you. You need to know what's in your history before you file so that there's no surprises when you go to your interview. That's really what you want to avoid, surprises at your interview. Reasons for USCIS to deny your case. So even if you don't have a criminal history, if you did have a case that was denied by USCIS because they didn't believe your marriage was real, they thought it was fraud, or that you lied about something in your immigration history, that's going to come back to haunt you when you file for this, unless you're prepared for it. Okay. So I've had a couple of those happen with my clients, and we were able to overcome them by just being prepared, by presenting information, getting statements, getting documents, all these things ready to go. I had a client that was in the same situation. Most of the complications that I talk about with you is based on personal experience. And these are experiences that we have went through and we have helped our clients through. Okay? And now that client is applying for citizenship because she has been able to prove that USCIS, you're wrong. My marriage is real. My marriage was real. Just because it ended in divorce doesn't mean that it wasn't real. And your reasons for saying that it wasn't real is false. It's just speculation. So we were able to get that person approved and get them now filing citizenship right away. So that's the great thing. That's the great thing about this act is that because your physical presence is from 2014 and they're going to backdate your green card. So when you get your card, your residence since date is going to either be November 20th, 2014, if that's the documentation you showed, right? But if you showed documentation showing that you were here from 2011, right? That's the date that will be there. So even if, let's say, you only presented documentation from November 2014 to present showing that you've been here, you automatically qualify. Immediately, you get your green card to apply for citizenship. Immediately, because you already met the 5-year requirement. You should not wait. You should not wait because you already met the requirements for citizenship. Because all you need is 5 years as a green card holder in order to apply for citizenship and physical presence in the US. That's not more than 180 days, or that you didn't break your physical presence. So once you get your green card, under this act, you can immediately, even the same day that you get your card in the mail, apply for citizenship. That's one of the beauties about this and why I keep talking about it. Okay. If you are tired of hearing me talk about this, then I hope you, if you qualify, that you have applied. If you know people that qualify, that you have encouraged them to apply. And please do share this with anyone you think that will find this helpful, that you think may qualify and just doesn't know about this. Because if you are out of status in the US and you could potentially qualify for this, this is a life changing act. So, if for people that were here, that were in the US, let's say in the 90s, you would have heard about the Life Act, which is basically an act that was passed by Congress that says if you were in the US before 1982, yes, if you were in the US before 1982, you can apply for amnesty. And this was not country specific. This was just if you were here, it was a blanket thing. Some people qualified and were able to get their green card through it. Some people didn't qualify. But this act, the Liberian Green Card Act, is country specific, unfortunately. It's not a blanket amnesty, but it is specific to Liberians. And I want to make sure that if you qualify, that you know as much about it as possible. You know how to apply. You know what the deadline is, which is November 20th, 2021. If, I'm sorry, December 20th, 2021. If Congress extends it, as always, I will come on here and I will tell you the good news that it was extended. So if you missed the deadline and it gets extended, you can come here and keep checking to see if it was extended. And if it is, I will let you know. As always, I will let you know. But yeah, that is the two main complications that comes with applying for this act. It's not whether you worked without authorization, you came in without authorization, all those things are waived. But the criminal convictions and the fraud and misrepresentation, those are the things, those are the big, big things that can come and hunt you when you apply for this act. So if you have applied for any immigration benefits in the past and they were denied, you should be having conversations with your immigration lawyer to make sure that you are preparing yourself for whatever that can come up during the interview and preparing yourself for anything that comes up after the interview that you need to respond to. So we want to make sure that you are taken care of, that you know all the information you need. And if you have any questions about this or anything else, you can book a time to talk to me over Zoom or in person by going to lilylegal.com or by calling the office at 508-443-1788. You can also send us a WhatsApp message on that number to request a time to talk with me. Okay, so that is all I have for you for today. Thank you for your time. And remember, if you like this video, hit the like button. If you know someone who needs to hear this, please do share it with them. And if you are listening in a place that you can subscribe, like my YouTube channel, and you don't want to miss anything, go ahead and hit the subscribe button. And once again, I am Lillian Chukwura. I am the owner and attorney at Lily Legal, and we do immigration law all day, every day, and we do it well. Bye for now. I will be back next week, Friday, same time, 12 p.m. Eastern Standard Time, with more immigration chat for you. Bye now.